When people think about getting an estate plan done, their first thought is, should I get a will done? Should I get a trust done? What are my options? But while you can think about these options, there are a couple of things that are essential parts of every estate plan, regardless of whether you get a will or a trust and whatnot. And I'll hit some of the highlights, right? So the first thing you need is something called the financial power of attorney. It's basically, you could be married to your spouse for 20 years, but if you get into an accident tomorrow and you're incapacitated, then the banks will not let you operate your spouse's bank account because you don't have this express authorization. So that's something. It's called a medical power of attorney. The second document you need is something called a healthcare power of attorney. A healthcare power of attorney is basically, if you're incapacitated, your spouse automatically will not get the right to make decisions on your behalf. Once the doctors kind of lay out all the options for her. In fact, the hospitals won't even share all these lab reports, these MRI reports, so whatever tests they run on you, those reports won't even be shared with them. So to get that, you will have to go to court in Texas. There's a proceeding called guardianship of the person. It could be expensive, long, or in an already stressful time. You want to avoid that, and the way to do that is to put in place a document called a medical power of attorney and something called a HIPAA release.